Everybody's time is valuable. We have two other committee members here that are in their office now, walking across. Again, I want to welcome everybody. This is the Insurance and Labor Subcommittee for the Georgia State Senate. It's Monday, March 23rd. We're going to start at 6:02. We have 5 bills we're going to look at today: HB 250, HB 1274, HB 1344, HB 1262, and HB 1263. Our subcommittee members today are Senator Harbison, Senator Kirkpatrick, and Senator Steele. I'm State Senator Randy Robertson, and I've been asked by Chairman Marty Harbin of Insurance and Labor to chair this. I want to thank my staff, Jack Rogers, my legislative assistant, for all of his hard work on this. Gwen Andrews, my aide, Will Lazarus, the intern for Senator Steele, for all their work this morning, everybody in Senate Press, Legislative Council, and the Secretary of the Senate, Jack Tripp, and his entire staff. I would be remiss if I didn't thank the McDonald's restaurant on Ponce de Leon Boulevard. And I see their dear friend in the back of the room. I stopped in Friday and had a 2-minute conversation with a lady, and she goes, "Yeah, it'll be ready." And I didn't have a lot of confidence. I pulled in this morning, went through the drive-through window. When I pulled up to pay, they handed me the food immediately. They had already done it. It's a 24-hour McDonald's. If you're in Atlanta at 526 Ponce de Leon Boulevard, which everybody knows Ponce de Leon died looking for the Fountain of Youth, and I may very well die of the same thing. But I want to thank Nadia Matthews and all the folks there. Before we get started, we're going to say a prayer, if we can, like we start every committee. This past week was a rough week. I lost a good friend, Alan Humphrey, who worked with me in the sheriff's office for over 20 years, suddenly passed away at 57. And a dear good friend of mine, Bill Reeves, a good friend of mine, and Senator Harbison's, who was a pillar of the community in Columbus, Georgia, and a great man. And every time you saw him, no matter what he was doing, he looked like he came off the cover of a GQ magazine. Just an incredible man. So with that, I would ask the Dean of the Senate, my dear friend and mentor, Senator Ed Harbison, if he would open this subcommittee hearing. What mic are you on, Senator?
Good morning, God. Father God, we thank you for the blessings of this day. Give us vision, godly vision, to solve the problems of the people of the state of Georgia in the most humane and moral possible way. We ask these things in Jesus' name. Amen.
Amen. Thank you. Okay, with that, we'll start out with HB 250. Yes, ma'am. If you'd come up, we'll just ask you to have a seat. Yes, ma'am.
Thank you, Mr. Chairman. I'm happy to be here. Good morning.
Good morning, ma'am. Absolutely. Yeah.
I'm happy to be here. This morning, I bring you House Bill 250, and we're working off of LC 520988S. This is a Small Business Act, and these concern companies that are a type of co-employer. They assist small and medium companies with a variety of services. Utilizing the theory of larger numbers offers better pricing in many instances. They do things like background checks. They do the interviews. They may do the payroll. They do the tax remittance, if you want, different benefits, including retirement and other things. House Bill 250 will define what a PEO is. Right now in our state, we do not have a good enough identification of who they are, what they do.
Excuse me. What are you looking at?
What else are you on?
I think this is at 520988S.
We're on an earlier version.
Which
Yeah.
one do y'all have?
Your as passed was
0804 substitute.
Is that the as passed House version? Or?
Yes.
Yes.
Okay.
I'd be happy to give this to you.
while she gets that,
Actually,
Madam, if you,
sorry, Mr. Chairman.
yeah, go ahead, absolutely.
We presented the chairman with a substitute about 3 weeks ago.
Chairman Harbison?
Harbin.
Harbin, I'm sorry.
Yes.
Yes.
And we were under the assumption that we were operating off that. So, but we're happy to operate off any version that the committee chooses.
Well, what I want you to do is, I want the testimony that best reflects what y'all want before this committee.
Correct.
And so I'm very comfortable with, if you can use the version you have if Gwen, would you go check, see, yeah. And Gwen will go and look for the latest version, but you present exactly what you would like for us to consider.
Okay.
Any changes y'all have made or anything like that, we take all that into consideration, because this is what we're hoping to hand to the chairman this afternoon to get you guys where y'all need to be.
Great. Well, I would ask Gwen if I could, please, are you about to go
Yes.
get some different ones? Let me give you this. We really, there's one substantial difference between the
Okay.
as-passed House version and the one that we're asking the Senate to consider today. We had a subcommittee, just that.
So the substitute you gave to the chairman was not the one that passed the House?
No.
Okay.
The one that passed the House the one that we gave him is identical to the one that passed the House, with the exception of really the next to the last page. We added 7 lines, which I just handed Gwen, to address a major concern that caused the bill to bog down last year.
Okay. And this was something that both sides looked at and felt that these 7 lines would solve a problem or get us closer to where we need to be?
I wouldn't want to speak for the other side
No,
about
I'm just,
solving
yeah,
problems.
that's the reason I said get us closer to where we hope.
But I believe, Mr. Chairman, that this is something that we've put forth as an industry in other states that has been agreed to by some of the people that won't agree to it in this state. So we're doing what we can to move in the direction to create good policy.
Okay, I appreciate that.
Thank
And
you.
I'll do whatever I need to do for Representative Taylor. She's a dear friend of mine, and I'm actually carrying a bill over here that I think's incredible that she's put together, and, or actually that we got passed the other day, I believe, on budgeting. So absolutely. So be happy to be flexible. Let's carry on. And we'll talk about those 7 lines when we get to that point.
Thank you, Chairman.
Thank you.
All right. The bill sets forth the foundation and rules to regulate PEOs. That's really what this is about, so we can define who they are, what they do, and it will help employers who are utilizing these type of services. Currently, the Labor Department has the statutory authority to issue rules and regulations on statutes under Title 34. The Labor Department won't lose that authority, but labor only regulates unemployment issues, so it's kind of a mixed bag who and what all they do. The PEO regulation, maintaining of registry and authorizations to promulgate rules and regulations will go to the Insurance Commissioner, because they do affect insurance also. So it's one of those issues that splits 2 agencies. So actually, I have with us John Walraven today, and he's probably going to go into the details about what the change is.
Absolutely. And I'll elaborate a little.
Pull that mic a little closer, John, please. Thank
I'll
you.
elaborate a little bit on what Representative Taylor had to say about the PEOs and what they do and who they are. PEOs, professional employer organizations, I like to just say it's like outsourcing HR. And the way that they do it is through what we call co-employment. And I like to say that co-employment is not much different than when you as a legislator step into the fiscal office. Once you cross the threshold of that door, co-employment would hold that for the purposes for which you were in that room, you're now their employee. So when you step back out of the fiscal office, you're back working for the General Assembly again. That's how 8,180 small businesses in Georgia provide HR services for their employees.
When you say I'm their employee, are you saying that they're responsible for all of my fiscal responsibilities or relationships with the state?
For the purposes for which you're in there, for the insurance, for the 401k, for the retirement plan, for your dental, all those kind of things. And what that enables the employer to do is provide big business employee benefits for their small business employees.
Right. So
It's pooling risk.
Exactly.
Yeah.
So when I cross that threshold, they all of a sudden become the resource point of my job within the General Assembly, right?
Right, they're in
Okay.
charge.
And so in the small business world, they contract out and take that same responsibility, correct?
Yes.
Okay, thank you.
And so they take the regulatory burden off your back so that you can get out to painting houses or doing plumbing or practicing medicine or whatever it is that your small business does. So what this bill would do is we would join 43 other states by creating a regulatory body within state government for these companies to come out, identify themselves, and pay a registration fee and help the industry identify the good actors from bad actors. Because in every industry, you're going to have some that really are going to skirt rules. And what this industry wants to do is be above board like they are in 43 other states and support the 196,320 co-employees that are living in Georgia. So what this bill will do is establish financial and reporting standards where solvency is important. It will require the registration, like I mentioned, it will be at the Commissioner of Insurance. It'll clarify the rights and the obligations in the contract that has to be in writing between the PEO and its client. And it will give the state the necessary enforcement tools, like the ability to revoke that registration in the event of some sort of malfeasance. And so that's what this bill really does, is we'll join 43 other states in putting together robust regulations and empowering the commissioner to do what it takes to regulate the industry.
Okay. Yes. Senator Fitzpatrick, Kirkpatrick.
I'm on 9.
You're on.
Yeah, okay. Okay, so I vaguely remember this bill from previous years, and the concern that was raised had to do with workers' compensation. Can you address that?
Sure. Workers' comp in Georgia is a no-fault insurance plan, right? So what other states have done is honor the contract between the PEO and its client. Just like with any other type of insurance, somebody is responsible for providing it. And this wouldn't change that. And so what we did on the House side was we asked Legislative Counsel to extract all language related to workers' comp from the bill. We didn't want to change the law on workers' comp. And it passed the House with 156 yes votes and 7 no votes. And so this bill bogged down, like you said, over this issue last year. And the reason is there was just this really horrible case where, and these horrible cases almost exclusively are reserved to the building construction industry. And what happened in this case was construction company goes to a PEO and he tells the PEO, I need workers' compensation insurance as part of my contract. But I only want to provide insurance to these 9 employees or whatever the number was. And none of those people do building construction. They were the ones that wore coats and ties and worked in the office. And so he goes to the job site and he holds that certificate of insurance out for something that it was not. And they directed that employee to stand in a wooden square. And they poured concrete up to his shins. And I've done a lot of work around concrete.
Yes.
Concrete is nasty. Senator Steele does a lot of work around concrete. Oh, I love concrete. I'm fascinated by concrete. But I'm not going to stand in the middle of it and pour it up to my shins. The guy was badly burned,
Oh,
couldn't
man.
work.
Yeah.
The bills were outstanding. And so, you know, what are we doing here? We're here to try to clean up his mess because the employer didn't pay for his insurance. The employer wasn't to be found when it was time to pay for his claims. So the way that
Where was this case?
DeKalb County was where they ended
So
up
it was here in
adjudicating
Georgia?
it. It's a Georgia case.
Okay.
I can't remember, Mr. Chairman, exactly where the injury occurs.
So this is a horrific example.
It was
I
terrible.
guess, an extreme example, would you say?
It is an extreme example.
Yeah.
And so the bottom line in this case was that nobody had insurance. And so they asked the PEO, who was defrauded by this construction company, to be on the hook, even though they didn't know the employee existed, and they were never paid to cover.
Was it the PEO's understanding there were only 9 employees with this company?
It was the PEO's understanding that those were the only employees whose payroll was run through, and the withholdings were made.
Okay. Did you have a follow-up? Did you have, okay, your light
I
was still on.
think there are people that are going to testify.
Yeah, okay, I just
to
want to
it.
make sure you guys,
Right.
your light was still on.
So let me explain this might be a good segue into explaining what this amendment does.
Yes, and we're looking at the amendment now, yes.
Yes, Mr. Chairman. This language was NCCI approved. This is workers' compensation language. This language, it's 6 lines. It's the next to the last page of the substitute. And what it does is it gives exclusive remedy to either the PEO or the client, irrespective of who obtains the workers' comp coverage, and states that the last sentence, nothing in this subsection shall be construed to exempt either the client or the PEO from compliance with the provisions of this chapter. Nobody is looking for an out. Nobody's looking for a loophole. Nobody's trying to create an opportunity where they can leave an injured worker without coverage. This language was forged in the state of Missouri. It was an agreement between the Missouri chapter of the Big I and the my client, the National Association of PEOs. And so what we're trying to do is thread that needle and make sure that a Georgia worker does not go without coverage, and also preserve the authority for a PEO and its client to enter into a valid contract.
Seems reasonable, yes. Anything else you'd like to say about it?
No, thank you.
Okay.
I just want
Yes,
to
ma'am.
add that if you've been around insurance long enough, you know there are going to be bad players, people trying to commit fraud. My goal here is to put regulations where the buck is going to stop. Georgia does not have something that directs what's going to happen, and that's what this bill was to do. Identify it, find a place where we can have someone it can go after and ensure the bad players are booted out.
Yes, ma'am. I appreciate that. Thank you.
Thank you, Mr. Chair.
Senator Steele.
Good morning. To the amendment, the new section that we're looking at here, the biggest concern that we've heard, and I've met with y'all and some folks in the audience more than a couple of times about this, the concern is that payroll companies that do PEOs don't really understand the work comp space. And so, John, to your example that you gave, that there might not be the right coverage because they don't understand the way an agent would. And that's why the agents were kind of pushing back on this. Can you speak to how this resolves that, and that the PEOs, the payroll companies that are offering this, are going to be able to ensure that the employers, so you referenced me working in concrete, we have over 100 employees working in concrete every day. So if there is an issue and we're using a PEO but we don't have the right type of coverage, how does this ensure that?
The PEO purchases the coverage from an agent. The agent is fully authorized and always available to explain coverages. The carrier has got to be licensed within the state of Georgia to be able to offer it. It would be no different than going to the HR office here or at Coke or at a small medical practice in Savannah. There wouldn't be a bit of difference.
Thank you.
Thank you.
I'd like to add,
Yes,
I
ma'am.
am an agent, and I've been a licensed agent for at least 30 years. And it's my responsibility to make sure my agent knows what they're, as agents that work for me and myself, that my client knows what they're buying. That's why I carry E&O. It's up to that agent to make sure you know and understand what they're selling and what they're buying, because that's your job as an agent. We all have a job, whatever it is, and part of an agent's job is to make sure that their clients are covered and that they fully understand what they are buying.
And if we go out and buy insurance, whether we buy it directly from the agent or somebody else, we're responsible for doing our due diligence to make sure we're buying exactly what we think we need. Is that not correct?
That's correct.
Yeah, and so the responsibility rests on everybody in the chain, I would say. Would you
You're
agree
right.
with that?
Yes, I would agree with that.
Yes, ma'am. Thank you. Any other questions from the committee? Thank y'all. I appreciate that.
Thank you, Mr. Chairman.
Do we have the sign-up sheets?
Thank you.
Let's go grab them. I don't know where Gwen went. Yeah, they're going to grab them. Yep. Thank you. John?
That was me.
Yeah, yeah. Michael from Insperity. Michael, Insperity. Michael, if you'll come down and sit here.
And Dustin as well, if you
Sure,
could.
absolutely. Yeah, Dustin, if you'll move to the middle mic, please.
Yeah.
So we'll have two
got you.
and three on. Gentlemen, y'all have heard the presentation of the bill?
Yes, sir.
Okay, mics are on, and you're welcome to testify.
All right. Thank you, sir. Well, thank you, Mr. Chairman, members of the committee. My name is Michael Kreider. I represent Insperity. We're one of the nation's largest publicly traded professional employer organizations, PEOs, operating around the country and here in the great state of Georgia. We're IRS certified, and we are an industry leader in providing full-service HR solutions to small and medium-sized businesses here in Georgia. We've been operating in the state for decades. We have over 1,700 small business clients, representing over 11,000 worksite employees in the state. So I don't want to rehash too much, but just to clarify again, Insperity, like other PEOs, we do a whole host of things for our small business clients, right? We prepare payroll, we remit taxes all across the board, we administer UI, provide workers' compensation, provide benefits, and these are all, to the benefit of the small business. I like to say it's like the easy button for the small business, that right at their fingertips. Oftentimes these small businesses or entrepreneurs don't get into business to be employers in the legal sense of the word, right? They want to promote their product or build a product or do what they do best and do that, and that's where a PEO comes in. That way they're able to support their families, support their communities. I think you had mentioned it earlier in your office, many times these folks don't have the money, the wherewithal to hire internal HR people. They don't have the money to hire inside legal counsel, and that's where a PEO steps in and does these administrative employer functions. That's what John was getting to about, they run their business because they know how to do it best, and we do the back end stuff to help them stay in compliance and to do what we do best, right? And just real quickly, I don't think John mentioned it, but people that use or businesses that use PEOs, they grow faster. They're less likely to go out of business. They have less employee turnover, and they're able to retain and attract quality employees, going up against bigger businesses.
And you base this on what?
So there are
data.
studies by the National Association that hired a third party, so it wasn't done by the association.
Right.
But they did a very deep dive into all of the, again, benefits that PEOs offer, and they found these kind of retention rates that the PEOs have. So anyway, I can talk all day about the great benefits of PEO, but I know we're here to talk about the bill. So Representative and John kind of mentioned it, but this will bring Georgia in line with the more than 40 states that do contain PEO, comprehensive PEO regulation, and that's every state, surrounding Georgia as well. As they mentioned, it would require the PEO to register with the state. It gives the state real teeth to go out and seek those folks that come in and penalize them if they are not operating to the provisions of the law. As you can imagine, PEOs handle millions of dollars of payroll, right? And this would assist in stopping those other industry or other businesses that come in masquerading as PEOs. They may not even be a PEO, but say they are, and distorting the market and just run away over the night with the payroll. This would help, the state be able to seek out those folks. Strengthen definitions, as the representative mentioned, there's very minimal definitions currently. I think this would help help the state understand, help the Department of Insurance, help the Department of Labor understand what they're really looking at, because PEOs we do a lot, right? And so it would help them really, it clarifies the various functions that we perform. And it really does resolve the most common legal issues that we've seen. Oftentimes this really helps before they get to a court or something. They can, it's here in the it's here in the law. We can actually point to something. I know workers' comp is a big topic of discussion, and I know that my colleague here, Dustin with Goldberg Segala, the law firm, is going to speak more to that. But I will say that the substitute, which brings back the old language plus those 7 things, or 7 lines, not things. Again, we worked NAPIO. Well, I used to work for NAPIO, the trade association, and we worked at the time with the Missouri Big I. They actually developed that language to pass it in that state to address some of the concerns that they had there. This law, or that language, it clearly delineates who's responsible party for obtaining the workers' comp, either the PEO or the client. It talks about who or how you procure that workers' comp, which matches up well with the NCCI that's currently in the state and their current rules under their manual, their basic manual. And it requires additional, or provides for additional reporting to the state and to the NCCI for those clients that go in and out of a PEO relationship, and which is helpful in establishing the experience modifiers that the state bases so much on. And I'd add, I'm aware of no instances since that law passed in Missouri of the so-called coverage gap. I've not seen any cases, and we believe it's a fair option. I also don't believe, and I believe Dustin will talk about this possibly, I don't want to put words in his mouth, but I don't think it supplants or upends the existing laws with respect to construction. 3498, for instance, which I'm sure our opponents will speak to, but there's nothing in here in my mind that would remove that would leave it in place for those specific instances. So I will stop there. I'm happy to answer any questions. I do think this offers worthwhile consumer protections. Again, it gives the state, real teeth to come after those that are operating not to the letter of the law, and at the appropriate time, I'll stand for any questions.
Thank you. Chairman Kirkpatrick.
Thank you. My question is, does this allow the PEO and the client to control liability by contract?
It would, I believe so. I mean, I think in the CSA, it states, who's responsible for what. I think one of the bigger things outside of workers' comp, for instance, would be in the medical field. Let's say a doctor poked someone, right? Is the PEO responsible for that? Well, no, we're not the licensed physician. We're not there. So we would contract that away and say the liability would fall to the doctor, not to the PEO, should that person be injured. But again, that's not a workers' comp question. That's a liability question, right?
Okay. All right, Dustin?
Sure. So, good morning, Mr. Chairman.
Good morning.
Members of the subcommittee, my name is Dustin Osborne. I'm a workers' compensation defense attorney for Goldberg Segala. I practice in New York and Georgia, which I know is an interesting combination. So I've seen, I've represented employers, carriers, and significantly PEOs throughout multiple states. And from a workers' compensation perspective, what this bill does is, as John and Michael mentioned, it brings clarity to a structure that already exists in practice. So PEOs are already widely used both in Georgia and across the country, and this bill provides the exact statutory framework for how those relationships are meant to operate. So the inclusion of the language mentioned that Michael touched on from Missouri is particularly important because it reflects the model that's already been implemented and functions effectively. So it ensures that within the well-defined... Sure.
Yeah.
Oh,
Cool,
sure.
yeah.
Sorry about that. So it ensures that within a defined co-employment relationship, both the PEO and the client are considered employers for purposes of the workers' compensation system. And it also makes clear that both the PEO and the client company remain responsible for compliance with the law as well. So, and Michael just touched on this as well, and I'm sure we'll hear about this going forward, but it does not upend the existing framework under OCGA 3498. The principles of vertical liability in construction and similar industries remain fully intact and continue to apply to parties who control the work and the job site. The bill does not replace that structure, it operates alongside it. And it's tailored specifically to PEO relationships, which are fundamentally different than the contractor-subcontractor arrangement. So what we've seen in Georgia, like the case we talked about with Robles, it's without a clear statutory framework, which just leads to resolving the cases on a case-by-case basis. That creates uncertainty and inconsistency, which is typically good for nobody but the attorneys who have to litigate it out. The bill directly addresses that by providing the predictable structure that aligns responsibility with how the relationships are meant to operate on a day-to-day basis. So from a practical standpoint, this bill promotes consistency, it reduces the disputes over responsibility, and it ensures the workers' compensation system operates as it was intended. So with that, I'm happy to answer any questions on that.
Senator Steele.
Thank you, Chairman. Since you're in the work comp space from a legal defense standpoint, how does this cover things like, I don't know, wrongful termination or sexual abuse, or like is all that built into this beyond just the standard work comp?
Well, unfortunately, I am pretty limited to workers' comp, and when questions like that come up, I have to defer to employment counsel in our firm. But I don't know if you can speak to this more.
I cannot speak to it as an attorney because I am not one, but I would say that again, as John and the representative mentioned, this still permits the Department of Labor, for instance, to review any and all laws that are in place right now. Again, it doesn't upend or supplant those. So if there is a violation for sexual harassment, if there is a violation, that would be addressed by the Department of Labor for both the PEO and the client. And a lot of times, if it's at the client level, right, the PEO will assist with those kind of compliance-related questions, or maybe point them. We won't represent them before the court, but we can recommend an attorney. But it would keep all those laws in place as well.
Okay.
And the PEO is perfectly equipped to assist, them handling those issues.
Thanks.
Any other questions from the committee for either? Thank you, gentlemen. I appreciate it.
Thank you very much.
Thank you very much.
Neil Herring. Neil, we'll just have you at mic 2 there in the middle, please. Go ahead, Neil.
I'm here. I'm here on 1344.
Oh, okay. Hang on, Neil. We're just,
That's what I thought.
yeah, you signed up for the wrong bill. Give
Did
us
I?
just a minute, okay? Bobby Potter. Come on up, Bobby. Yeah. You signed up for 2, right, Bobby?
Yes, sir.
Yeah. Thank you.
But I know which one we're on. Yeah.
Yeah, we're on 250.
Yes, sir. So my name is Bobby Potter. I'm here, I'm often here on behalf of State Farm. State Farm writes some workers' compensation coverage, but that's not why I'm here. So I'm here as chairman of the State Board's Advisory Council, about 100 folks that deal with all aspects of workers' compensation and have for 25 or 30 years or so. I've had my career mostly, other than this legislative work, as a defense lawyer in the workers' compensation world for a long time. So I speak today on behalf of the Advisory Council and then really at the direction on behalf of the State Board. When this bill came up last year, I and several other folks met with Chairman Taylor and expressed our concerns about that. when it come up the year before that, and the year before that, we had expressed some concerns about that. And I'll just relay some of those. And I would tell you, I met Tuesday of this past week at the request of Nancy Palmer at the Chamber and of John Barber of the Independent Insurance Association Group with some PEO folks to see what has changed, is there any resolution? And Mike Iverson, you may have heard him speak before. He's a member of the IIAG and an insurance agent and well-versed in this PEO world, certificates, what coverage is allowed and what might be excluded. So from that perspective, I would speak on behalf of the state board that what they want to do is maximize coverage wherever they can, so that if an employee is injured, there's coverage, insurance coverage, not just an employer that doesn't have coverage and might be liable. What I see in this bill, did last year and do again today, is it does provide a coverage gap that was referenced earlier. I don't honestly see that has changed. I would reference a couple of things in this bill, and John Walraven was at the Tuesday group and indicated the Missouri language that you all had heard, and that I don't really speak for John Barber except that he's not here, so I will speak for him because I heard him. He would say that's their independent agent group. He's got no relationship with them other than they do the same thing, but that's Missouri and this is Georgia. And Mike Iverson would have said the same thing. So none of that was binding. It might be helpful to you all, it might not be. But from the standpoint of what was indicated, that last year, John and others went to Legislative Council and said, take workers' compensation out of this bill. That's the problem. That's the concern on the House side. That's been the problem, so take it out. And I'm just here to tell you where I don't think it's taken out. So even without the new language, let me just point out a couple of things. Line 52 and 53, in the very beginnings of that, and that is it's the exemption of selling insurance, and that's the catch. So the definition of an agent or sub-agent, somebody that's in the insurance business, Section 9 of that says a PEO doesn't do that. So they're exempted from being an insurance agent. And the words workers' compensation were in the previous bill, at least I think they were. But at line 52, it allows the PEO, to the extent that such organization collects information from a client or covered employee, obtains, offers, or provides life, accident and sickness, disability income, and other types of insurance coverage for a client or covered employee. So other types of insurance coverage would be fairly broad, and I think that would include workers' compensation. In line 120 and 121, that's subsection 12. Professional employer services means the service of entering into co-employment relationships, and this is the catch, in which all or a majority of the employees providing services to clients are covered employees. All or part. And then in lines 252 and in lines 286 and 87, it makes clear that the PEO contract with the client controls. So those are the lines that are of concern. I do not think the sub-language added 3 weeks ago that it was touted from Missouri necessarily fixes that. And here's a couple of catches that I would suggest. The problem, really the fundamental problem with this, and one of the speakers said this really occurs in the contract or construction world. there was a reference to doctors, and I don't think this really applies to that. And I'm not here to speak against PEOs. Obviously, there's a bunch of them. They cover a bunch of employees. They provide a lot of services. And when John would indicate they kind of outsource HR, and that's great. And a lot of smaller employers would like that. But when they step into the shoes of providing insurance and sort of are an insurance agent, but by this bill, they're not an insurance agent, that crosses a line that provides some concerns and potential problems. In the pure workers' compensation world, every employer with 3 or more employees in the state of Georgia, every employer is obligated to have workers' compensation insurance. And they can do that in one of 3 ways. You all heard this bill of the Self-Insurance Guarantee Trust Fund last week. That one is a simple bill. Most employers buy it through the traditional market. Lots of folks sell workers' compensation insurance, big names that you would have heard many times, the Travelers, Liberty Mutuals, and others. That's one. Secondly is self-insureds, which was what that bill was about. And thirdly, self-insurance group funds. Some folks group together and have coverage that way. In each of those instances, it covers every employee of that employer. And it covers, in a sense, future employees of that employer. And that's important because if they have a insurance policy, or they're self-insured, or they're group self-insured, and they have 50 employees on Friday, but they got 3 onboarded on Monday, those 3 onboarded on Monday are employees for that employer, and they're covered. In the PEO setting, they use the term in this bill and throughout, covered employees. So those are listed. And the PEO obligation is to provide workers' compensation coverage and other stuff for those listed employees, which they call covered employees. So the non-covered or non-listed employees are not part of that agreement. They are not provided workers' compensation coverage by the PEOs.
Bobby, are there current employees where the employer uses the traditional market, where they have employees that are not covered?
If they've used the traditional market, their employees are covered.
Every one of them?
Every single one of them.
Okay.
Now,
So there's no carve-outs anywhere for any employee who works for a particular company if they use the traditional model?
no, sir.
Is
Now,
there any prohibition if a PEO negotiated for a company with a traditional market provider that all of their employees would then be covered?
they may say something in their contract about it. The way I have heard it, and I may not be answering the question exactly,
Well, what I'm saying is they have the opportunity as a PEO to negotiate a insurance contract, workers' comp contract with a traditional market provider that would cover every employee.
they probably would have that opportunity. I'm not sure it happens that way.
Right.
And they could speak to that, but I think the PEOs generally have a master policy that covers all of their, and it's the unique term in that world, co-employees and co-employers.
Okay.
But it's the employer and that's the client. That's who it is. Their client is a co-employer. And I'd call it, that's the real employer. Senator Still, that would be your company.
That's right.
And then there's this contract that says all of your employees are all of a sudden co-employees. And they're co-employees of this co-employer, which is the PEO. So it's this, it's not fictional, but legal fiction hybrid that's the way that would work. That's the example I've used last year a number of times. It just maybe brings some clarity. Is I'd say the Monday, Wednesday, Friday employee. Employee is hired on Monday with traditional insurance, traditional employer. So let's say it's with Travelers, and it's construction company X. That employee is covered under workers' compensation from the very beginning. If there's a training program, they're covered from the training program. If they're on the way to work, they're not. That's a different story. They're not quite there yet. But once they're an employee, they're covered. If that circumstance is in this PEO setting, it could be that on Monday they become an employee and they're working for Senator Still's company. On Wednesday, they're injured in some way. On Friday, this HR function and the payroll function has been processed. It goes to the PEO, and the PEO lists that employee. But they weren't listed on Wednesday when they were injured, and they weren't listed on Monday. And then there would be finger pointing that says, well, that's not a covered employee, so we do not cover that. Now, part of what I understand they would say, and I think that's accurate, is that in the contract, they would say to the client employer, let's just call it the real employer, you need workers' compensation for those folks that are not covered, and it's your obligation to provide that. I think that might be spelled out. The catch is if the client, the real employer, does not do that and say, we just need insurance, and we need workers' compensation insurance because we can't bid on this job unless we have coverage and we need it. So that's written under the PEO and it's provided, and there's a certificate of insurance that the real employer, can then take to the construction company for whom they're doing sub work. They're the plumbers, or they're the electricians, or whatever function they're providing. And they've said, we have a certificate of insurance. And as John Walraven had indicated earlier, maybe that only provides the folks that are inside at a desk wearing a coat and tie, and it does not provide coverage for the people that are on the roof, that are in the high-risk areas. That's the coverage gap. And I don't think this bill addresses that. There may be wonderful things that PEOs do in the HR world and other things, and other types of insurance. But this, to me, likely codifies the potential of that gap. And for that reason, we express those concerns.
I appreciate that, Bobby. Any questions? Senator Steele.
Bobby, thank you. I think part of the confusion on this is we've got a few different versions floating around this room and online, and the version that you're referencing that doesn't have the Missouri language that was in the email, the summary for section 3-6. I'm looking at the email.
I've got it.
That was sent to Ledge Council, but what's in the version of the bill that we were given doesn't address that. And it sounds like some of your concerns, maybe not all of them, might have been addressed if we're looking at the version that has that.
So I think I have that language.
That's my point.
Yeah.
The
That's
last
what I'm
7
saying.
lines.
Are you looking at the email?
It's not in the version that we are
Correct.
looking at.
So
Okay.
That
we-
amendment.
We started with version 0804, then we were given 0988, and now apparently there's another version, 0999. Chairwoman Taylor, what version are you looking at?
I have the 0988,
Yeah,
Okay,
that's
that
the
does
one you
not
testified
have-
to.
and that was to be amended, I believe, was the additional one.
So
I gave
And so we're talking about, we want to amend to cover your concerns,
With section 3-6.
but that's
Yeah,
not
right.
So-
in the,
So what I brought and had was
Yeah.
0804. Now, on Tuesday, however, John gave me this one sheet that I think is the last 7 lines that he has referenced, and a couple of those folks have referenced.
right.
And just in my view of that, it makes clear that both sides are entitled to the exclusive remedy provision under the code section, meaning for that injury, they cannot be sued in tort. So they get the benefit of that. Honestly, in the way I read it, I don't think it addresses the potential coverage gap in any way. Now, the gentleman who testified that he practices law in New York and Georgia and other places talked about the code section 3498 and mentioned the term vertical, which is a good term to use. That is that if let's just forget PEOs for a minute, if the employer in a subcontractor-contractor world, if the sub does not have insurance, then the contractor that hired that sub is responsible for coverage of all of those employees. They didn't know it necessarily. They may have said you got to have coverage, and they may have not told the truth, but it goes upstream, and they're responsible for that. And ultimately, the insurer of that general is responsible for that, and they will figure that out as to who pays what, because they'll do an audit at the end of the year and see how much payroll was associated with that. And if the sub was not covered, they get that payroll as well. So that's kind of the way that works. It goes upstream. But this is not an upstream circumstance to me. It is this co-employee, co-employer lateral thing that I don't think it would work that way, particularly when the first parts of this bill say this contract controls. The contract clearly is written by the PEOs to the advantage of the PEOs. And when in the Tuesday meeting, there was a suggestion, and I would suggest that to you all. This was coming from Mike Iverson. He would use different language than I might use. But if in this world, and again, PEOs do wonderful things and payroll and maybe provide other forms of insurance. It could be dental and health coverage, who knows? But in this world, for this, notwithstanding them saying we're taking workers' compensation out, it hasn't. So if they are to cover any employee of the client employer, they should cover all of the employees of the client employer. That would solve it, to me. If they cover any, they cover all, or they cover none in the workers' compensation world. That discussion occurred on Tuesday, but that's, I think, not something that the PEO folks were interested in doing. But I can't speak for them. But
Senator Kirkpatrick.
So since we weren't in the Tuesday meeting and we don't know what the conversation was, I guess my question is, you pointed out a couple things. You pointed out on line 52 and other types of insurance coverage. And then on line 120, you pointed out all or a majority of the employees. It seems to me that adding this amendment without addressing the other parts of the bill that you pointed out is a little hard for the committee to deal with, because we haven't amended the bill. The sub, to me, looks just about identical to what the version that you had. So it seems to me that it still needs some work from the standpoint of fixing the things that are going to put anybody at risk who should normally be covered under workers' comp. But that's just, unless I'm missing something.
yes, ma'am, I would agree with that.
Okay, anything further, Bobby?
No, sir.
All right. Is anyone else here? Todd, did you want to speak to anything?
Not on this bill.
Not on this one? Okay. Does anyone else want to speak to HB 250? Madam Chair, would you like to say anything in closing?
Thank you, Mr. Chairman. Thank you, committee, for listening. I do have concerns about workers' comp. We all do. We want to make sure that the people of Georgia, whether it be through a PEO or through a private employer, has the appropriate coverage. Some of the information given is relevant, and I do understand it. Some of it, on like line 51 and 52, 53, that area, those are not selling insurance. They made it sound like they were selling insurance to employees. That's not what they're doing. It would be like your human resource department offering coverages. Again, it's not a sales process. It's an enrollment more so than that. But getting to the workers' comp, which is the heart of this, the intention is to see that everyone is covered. My biggest concern, I guess, is the overall picture. We have we have people out there that do not have the appropriate coverage and treatment that they need to have right now. And I want to see that fixed, and of course, we're ready to cooperate any way we can to see that the citizens of Georgia that use a PEO, which is tremendously helpful to our small employers. So we're open to making it where it's feasible to everybody. Again, you have to enroll, you have to know who's covered, and it does all wash out at the end when they do that audit. So I appreciate your consideration.
And Madam Chair, on this, the other insurance companies, that could be vision, that could be dental, that could be any of that
It could
stuff,
be-
right?
Yes, it could be pet insurance. It
Yes,
could be
ma'am.
legal insurance. It could be anything. It is not, they are not negotiating with an employee on workers' compensation. They are offering just like a HR department would.
Many of these other benefits that in today's world, a lot of these employees shop and look for before they go to work for a company, right?
That's correct. That's exactly what they do. And a lot of small employers cannot offer it. And
Yes,
this way
ma'am.
they can. That's the purpose of it. But it's like the HR making these offers to an employee. You take it or you don't take it. But it is not to negotiate workers' comp. In fact, the PEO has used their numbers to negotiate the best rates so that these employees can have that coverage.
And would it be not true if we tried to list every type of special sub-insurance that's out there, this bill would get a lot longer?
Yes, it would.
Yes, thank you.
Thank you. Thank you very much.
Thank you.
Okay.
Yes, ma'am. Chairman Kirkpatrick.
Would you mind addressing the reason that the bill says all or a majority of the employees?
I'm sorry, all what?
All or a majority of the employees?
Is there a line?
Yeah, 250, sorry, I had it. 120.
120. Well, there may be instances, for example, management people sometimes are not included with the PEO. I would say that you, as an employer, a small employer may take the ownership out and not be part of that program. They may have a separate indication. So everybody that works there, quote, I have a small company. I would exclude myself and my son who run the company. We don't get the same benefits as we offer to our employees in every instance. So that could be part of it. Management could be different. You could have some, I hate to say, different classifications. It could be part-time people. Thank you.
Anything else you'd like to offer, ma'am?
No, thank you very much. I
Okay, thank you
appreciate it.
very much. And I want to be transparent. One of the committee members asked me about the possibility of tabling for corrections and things of that nature, and I appreciate that. Another committee member mentioned to me about not voting in this kind of process. What we're here to do today is we're here to vet this legislation, make the best determination for what to do, and I'll be reaching out to the chair of insurance, which is Senator Marty Harbin, and I'll be recommending that he call SB 250 to the full committee for consideration, and any amendments and anything that you would like to offer, any further discussion that you would like to have with him, I would welcome that, and am more than willing to be a part of that conversation. We've got experts here. I would challenge anybody with Senator Kirkpatrick's understanding of workers' comp, and Senator Steele in the employment arena, and Senator Harbison in the insurance arena. But I feel that we have to find a solution. We have a lot of people out there in these subcontracting jobs and in these small businesses that do need some support, and asking them to go out and carry the full weight of this would eliminate their business very quickly. And so I appreciate the presentation. I appreciate the subject matter experts that came in and enlightened us on this. And again, Madam Chair, I have a tremendous amount of respect for you, and I always appreciate you and appreciate your compassion and passion. So thank you. And we'll now move on to the next bill. What's next? Okay, now we'll move on to HB 1274. Chairman Reeves.
Thank you, Chairman Robertson and members of the subcommittee. If I may invite Chairman Lumsden up with me, we're
Yes.
prepared to present all four of these together because they are related. And
Let's do it.
If you wanted to put them all together on a 1344, I think Legislative Council can do that pretty quickly. But thank you for hearing these four bills. House Bill 1274, the Auto Excess Profits Bill. House Bill 1344. There was an error in the title. This is the Insurance Affordability Bill.
That's right.
House Bill 1262, carried by Chairman Lumsden so far. That is the increase in surprise medical billing fines, in mental health parity fines, and in general fine authority for violations going from doubling to 5 times. And then the final bill, House Bill 1263, that is a premium tax look-back limitation for 3 years. Right now, it's arguably unlimited. One company did a look-back for 7 years and got $150 million back from the state, and that obviously caused a lot of disruption. But, Mr. Chairman, this is the product of the House Insurance Rate Study Committee appointed by Speaker Burns after tort reform passed a year ago. At that time, across the nation, insurance rates had risen about 60%. In 5 years, it was hitting our constituents in the pocketbook as well as Americans across the country. And so in Georgia, we went around the state this year. We had study committee meetings in Macon, in Savannah, and Gwinnett County, here at the state capitol. Senator Harbison, we were going to have one in Columbus, Columbus State and Aflac, and Minority Leader Hughley had made arrangements, but Chair Lady Mandy Ballinger passed away. Her
Yes.
funeral was that day, so we rolled that into the meeting in Macon, had an all-day meeting at Georgia Farm Bureau, but heard from a lot of citizens, got some good ideas from the people of Georgia, from the insurance industry, and also from neutral academic professionals. We heard from the University of Georgia's Insurance and Risk Management School. We heard from Georgia State's Insurance School. We even went out of state, across the line to South Carolina, heard from their top 10 insurance school, and studied the issues that we have. In 1274, the one you call first, this is the Auto Excess Profits Bill. This came from Florida. What this bill says is, if there's a 2 or 3 page index on the insurance rate filings, and one of the line item is expected profit. That's obviously something that insurance companies have to calculate when they're setting their rates. If they exceed that number that they put in there for excess profits by more than 5% for 3 consecutive years, they are mandated to give a refund to the customers and to do a rate filing to decrease their rates, because
Chairman Reeves, real quick.
Sure.
Would you read your LC number to me, please?
Sure. On 1274,
Yes, sir.
it is as passed the House. It is LC 52-9007. That's the same one that passed the House.
So you wrote it perfect to start with, and it came through that way, right?
I don't know about that, but in Florida, customers got $1 billion back, so that's
Right.
pretty close to perfect.
There you go, that's
so
right.
no changes so far.
Good
And
deal.
then on 1344, it's LC 52-1096S that I think is hot off the printer this morning. Appreciate your staff doing a great job getting that out this morning. And then the two other bills, 1262 and 1263, are as passed the House. No amendments on those.
Perfect.
So on back to 1274, the excess profits bill. During the study committee, we heard from a lot of people. I wish that if there are profits, that the customers could get that in the way of decreased rates. The best model we found was in Florida, because in Florida, one company refunded $1 billion and cut rates. Rates are going down. It's working there. So this is a good model from one of our border states.
What company was that? Do you recall?
Flow, Progressive. Progressive.
There you go.
I remember by the commercials.
Yeah.
So,
And so not only did they refund, but they also lowered rates
that's
at the
this
same
bill
time?
says you've got to file a rate filing to decrease, and there's also a refund provision in there.
Perfect.
Auto insurance, there are 9.1 million drivers in Georgia, driver's licenses. I heard from the DDS recently, so this will benefit probably more people than any other legislation we have this year.
Yep. Chairman Kirkpatrick.
Thank you. I'm trying to get my brain around, as a free market person, figuring out how we're going to tell private companies how much money they can make. Particularly, nobody spent more time fighting with insurance companies in this building than I have. But I just am concerned about that heavy-handed approach to regulating. I'm all for protecting consumers, but we've seen insurance companies leave the state because they can't afford to write here anymore. So can you just address that?
Yes, I share that position. I think that we ought to be friendly to business. That's how we've gotten to be number one, and we ought to be the number one place to do business going forward. And a lot of things in 1344 you're going to see welcomes insurance to Georgia and brings more companies in the market. Here's what this does. In the insurance rate filings already, anticipated profit is a line item. It's been there for decades, state by state, among the 50 states. That's something that's considered when setting rates. Sure. If the insurance companies overestimate or underestimate or miss that, and they're making more profit than they anticipated, then they've got to come back in and do a rate filing. These increases that customers have gotten in Georgia, they're going to come in and get more money if they're losing money. That's what's happened. And so this gives some benefit to the people of Georgia on the other side. If companies are making more profits than they anticipated, 5% per year for 3 consecutive years, they're required to come back in and redo their rates as well as refund those excess profits. And it's working. In Florida, it's working well. The insurance companies, one of the companies there, American Integrity Insurance, has come to Georgia and entered the market since last year when tort reform was passed. And so they're not only doing good business in Florida and making good money, they're coming to Georgia because of some good things we've done. But this is something that a larger state next to us has done well, and it benefits customers.
Thank you.
And Chairman, would you agree that when the insurance company lose money, they have the opportunity to come back and raise those rates, and when they miss expectations on profits, there should be some balance offered to the consumer who purchased the insurance, in some cases based on that. I have a brother-in-law that shops insurance every year, and he looks at every part of the insurance offer, and so that factors in to his budget, into what he wants to spend. So we're looking for balance, not only with the free market, but with the consumer, especially on a fragile product such as insurance. Would that be correct?
Chairman Robertson, couldn't have said it better myself. I think I got in this position by the Speaker because I got 3 teenage drivers, so I shop it every year also. And I will say this, this year is a lot better than last year in terms of car insurance, in terms of umbrella insurance. Things have changed over the last year, and we want to keep that
And
momentum
what do you think the cause? Would you dare to guess what the cause of it being better?
2, from what we heard in the committee, number 1, enacted tort reform by 1 vote, and number 2, inflation, people absorbing that and getting used to it. Inflation and legal, those were 2 things that got mentioned time and again.
Thank you, Chairman. Yes.
Could you just tell me, are any of these bills that you're talking about sort of together department bills?
The reason we had them in different bills are that they were separate subjects originally, and some of them were easier to draft than others. But the insurance commissioner did identify. We asked, can we make sure that customers get savings when the companies are making excess profits? He found that bill in Florida. The premium tax look back. That hurt the state. That hurt locals when $150 million was clawed back 7 years after the fact. And then on the excess or the taking the fines from double to 5 times, the mental health parity violations and surprise medical billing, some people aren't quite getting it yet, and it's a cost of doing business. By taking the fines from 2 times to 5 times, that will really get that straight. And Chairman Lumsden, feel free to
point out that the fines on the unintentional acts haven't been updated in 15 years. The fines on the intentional acts have not been updated in 30 years. So this provides a little more bite, if you will, for those bad actors when they do make those violations.
So in response to your question, I would acknowledge insurance commissioners' help on 1274, 1262, 1263, but all of them came during the Blue Ribbon Study Committee from August of 2025 to the present.
Certainly that is part of his role, But this is about policy. This is about what we need to be doing, regardless of who it is that's doing it.
And didn't we make somewhat of a commitment during tort reform that we were going to look at the full scale of everything involved in that, including insurance, including health care and everywhere? And so we weren't just going after one particular group. We were trying to solve a much bigger problem. Does that
This
not
is
be
definitely
true?
the follow-up. And in Florida, the savings have come through doing both legal and insurance. That's what we're doing here.
And I think we're following through with a commitment that we made.
Absolutely.
When the opponents of tort reform came to us and gave us, saying that they weren't the bad actor was the other person, we explained to them that we were going to look at the entire thing, not just one aspect of it, and I think this moves us in that direction.
Absolutely.
Thank you both.
The speaker's scope in that study committee was insurance rates and claims processing. So 1344 that you'll hear in a minute will have more on the claims, but definitely this is the follow-up and the commitment. One more thing on 1274. Friday afternoon, after I got you that sub on the other bill, I got some feedback on, if you look at line 85 on House Bill 1274, there's a provision in there that has December the 31st, and that was borrowed from the Florida Act. And so we got a paragraph on Friday afternoon from somebody knowledgeable about Florida that ensures that any customer who's paying premiums during the period that is deemed to be an excess profit period, that they're going to be eligible for the refunds. That $1 billion in Florida, there were actually some customers who paid who didn't get it because that December the 31st, I've got a paragraph to substitute on subsection 2 on line 85 if I can distribute that. Thank you.
Absolutely.
All right. And I think that concludes remarks on House Bill 1274, so we would just request for that paragraph to be substituted on line 85 so that it goes broader than just the December 31st date, so that it covers all policyholders within that period. All right.
Yes, sir. Let's
This
keep
will
running.
definitely make insurance more affordable for drivers. House Bill 1344, this is the study committee bill that has the good ideas that we heard from that study committee. And by the way, 18 members of the House served on that. And, I called each of them before we started meeting in August and got their idea. And so we addressed auto insurance, we addressed homeowners insurance, business insurance, property and casualty. People asked about health insurance. There are other committees at the Capitol that deal a lot with health insurance, but we kept the door open on this. And so this bill addresses insurance rate and claims processing in all of those areas. We've looked around the country, and some states will do one or two of these topics, but none of them are doing all of this. So I think Georgia's got the strongest approach to insurance affordability of anywhere we've seen in the country. So let me walk through this. First of all, I've got a letter that you may have gotten from the National Insurance Crime Bureau, and it points out that insurance fraud is not a victimless crime. This bill addresses insurance fraud. It does a number of things to crack down on insurance fraud, including increasing fines and giving the insurance commissioner the ability to deal with our DAs more easily. At our Gwinnett meeting, we had people from the Gwinnett DA's office come out and say they are ready to prosecute insurance fraud. We've had many other DAs step forward and say the same thing. So cracking down on insurance fraud, enforcing our uninsured motorist laws. 9.1 million drivers, about 20% right now are uninsured. That's nearly 2 million uninsured drivers. And so this bill focuses on uninsured motorist compliance. This bill went through the whole code, as Chairman Lumsden pointed out. It's been several years since we went through Title 33 on the insurance fines. We updated about 40 different insurance fines for wrongdoing by insurance companies against policyholders based on the law or based on the policy. Some more summary on this. The premium tax, our local governments get a large amount of premium tax, and one of the reasons for your substitute, ACCG came to a meeting that we had last week and gave us some good language to harmonize the premium tax provisions with other parts of the code. But this makes sure that our local governments are looking at savings for customers when they receive that money, and they're making some sort of a written record of promoting policies to save their residents money, such as enforcing uninsured motorist laws or helping senior citizens shore up their homes. Speaking of that, the Georgia Storm Mitigation Program, we heard of a good program that's working in several surrounding states where people with homes in vulnerable areas are getting help with shoring their homes up so that it's going to prevent claims. An ounce of prevention is worth a pound of cure, and so we have a good program in this bill to expand to keep our homes from creating homeowner claims. Recruitment and retention of insurance companies. We've got a provision in there where the insurance commissioner can work with the Department of Economic Development to aggressively invite companies to put their regional or national headquarters here in Georgia. We've all heard of the California to Texas pipeline. I think we've got a California to Georgia pipeline. But if you look at companies like Aflac, like Primerica, like State Farm, who have big offices in Georgia, those are good jobs, and they're also serving our local communities and our insurance customers when they're here, when they're home in Georgia. So inviting those companies to move their offices here to Georgia more aggressively.
And that's a sensitive subject with myself and Chairman Harbison, because the home of Aflac is in Columbus, Georgia, but they're licensed in Nebraska.
That's right.
And I want them to grab that certificate and bring it here
Well,
to the Peach State.
Absolutely.
One of the things we put in there is, evaluation of things that might be an impediment.
Yeah.
The premium tax, I think, is one issue. That's a longer-term analysis, but that's something that we've highlighted. Anything to get the companies to move here to Georgia would be a good thing, and I did learn that through the process. They may be headquartered here, but they're really officially headquartered
Yeah.
elsewhere. Let's see, excluded drivers. There's modus operandi that Speaker Pro Tem Jan Jones found where some people were intentionally saving money on their insurance by excluding a driver, but they're still giving them the car and the keys. And so this defines an excluded driver who gets the car and keys as an uninsured motorist to be able to stop that scheme from proliferating in Georgia. And that is a good overview of the bill. I'd be glad to answer any questions about it. Again, on the title on line 31, it's the Insurance Affordability Bill. I think the good name that's on there is Senator Still's title from another bill. So this is 1344 is the Insurance Affordability Bill.
How in the world does that happen?
Long story.
Donations?
It happens. Absolutely.
That's right.
Chairman Still.
Thank you, Chairman. Our friends from ACCG, you said, added about 124 lines to this bill from the as-passed version, and then I think Todd's here to speak to another potential friendly amendment that looks like I think it may already be added, so when ACCG comes to testify, that amendment is inserted into lines 236 through 240.
Correct. It was just 4 lines. It was not lengthy at all.
Yeah.
That's
It's
right.
just the as-passed version of this bill and this version it's about 2 pages longer. So,
you bring up a good point. Two differences, substantive differences in the House passed version and what you've got today. Number one, the ACC amendment. Number two, there was a judicial security measure that the courts brought, State Bar brought. There was a judge who got shot in Indiana last year after sine die. You had a violent defendant whose trial was scheduled. He tried to postpone his trial. The judge said, no, you're going to trial next week. That violent offender enlisted accomplices. They looked up the judge's home address. They went out to the home. They shot through the door, shot the judge, shot through the window, shot the judge's wife. And that was all because the address was exposed. This bill adds in the judicial security measures and some real estate title claim special master measures that have been requested by the judges and the State Bar.
got it. Okay, so then
That accounts for the link, the
Thank you.
extra couple pages.
Good. And that's all great language to add. Going back to something you said kind of at the beginning when you started presenting these packages, and this is kind of a dual question for you and Chairman Lumsden. because these are 4 separate bills, because they do address different subject areas, but last week, through the magical world of the odyssey that Ledge Council can bring us on, they mysteriously appeared on a really great Senate bill, had to do with ambulance billing. If they're all brought into that, but they're 4 separate bills now, and you pass them as 4 separate bills, how then do we get this across the finish line to make sure that it all gets done?
I think the easiest way to do it would be to put all 4 bills this morning into 1344. That's quite frankly, I think, the easiest way to do it. These were drafted at different times, but they are in the same code. They are regarding the same subject, insurance affordability and claims management. We've worked with legislative counsel. These were finished at different times, but they all relate to the same subject matter. So I think putting all 4 into 1344 is the easiest way to get them across the finish line.
Got it.
And I'll tell you, having waded through 1013 a few years ago, we see where we can get a lot accomplished by doing that at times,
Right.
instead of just piecemealing it. And we did the same thing with tort reform. As y'all recall, in years past, we would end up with 12 different pieces of tort legislation. And finally, we realized that we were overcomplicating the process and just pull everything under one umbrella and get it done.
Majority Leader was here earlier.
He just stepped
He
out.
was on the committee and signed the bill. Speaker, Minority Leader Hughley. We have a bipartisan group from around the state who signed 1344, and I think everything going in 1344 is the most efficient way to do it.
Okay.
Chairman Lutz-
Chairman Harbison, I think, had a quick question.
Very briefly, under the mitigation program, how do you provide grants? How does that work? Is that you apply with the insurance department? How do we do that?
That is currently, I believe, the program is authorized and in law, and this enlarges it. But the name of the program is escaping me, but several states have it, and what it could be government funds or nonprofit funds to help senior citizens and people in tornado alley or hurricane zones or flood zones have protection both on their homes and their neighborhoods. I know Houston did a lot after Hurricane Harvey to shore up neighborhoods that were vulnerable, low-lying areas and things like that. But this is something, it's located in South Carolina, this center that shows you how to, things like if your door opens out rather than in, it could keep things from, blowing in and blowing the roof and windows off. Just little changes where you can spend $100 and save $1,000, that kind of thing.
And we did pass some legislation a couple of years ago on fortified construction.
That's it.
Yeah,
we did.
which is a national plan, and it passed out of the Senate unanimously. I was proud to help a good House member over there with that legislation, and it actually lowers the rates to individuals who use the fortified construction model. It adds, where some people are putting nails in now, you're putting screws in there, and it'll help our folks along the coast and in those areas that
right.
have the worst problems with Mother Nature.
This beefs up the Fortified Homes program, and then
And I want to be clear, that's a national standard too. It's
right,
not
yes.
just state by state. It's solid. No
And
pun
finally,
intended.
the analysis, if I may, Mr. Chairman.
Yes, sir.
On the analysis in the last page on the synopsis, the bill allows insurance agents and other licensed persons with the knowledge of belief of insurance fraud to report. That's a requirement. That's really a requirement automatically for any insurance agent. Do I have that right? That if
On
you have
insurance
an
fraud?
yeah, you got it. That's a report for you getting your license. If you don't acknowledge that, you could lose your insurance license. I believe I'm correct on this.
that's right. And I think there
But
was.
you added it in here. I just couldn't figure out why. Just to reemphasize it or something.
That's right. And one of my favorite parts of 1344 is the late Steve Manners. He passed away in January. He was with the insurance department 38 years. He testified twice at our study committee. At one of them, somebody said, when insurance companies do wrong and they have these violations and fines, how is that considered in the rate process? And he said, by law, we can't consider it. This changes that. This allows all information at the insurance department to be considered when setting rates. So it allows agents and the insurance company to consider insurance fraud and violations and everything when analyzing these important issues.
And you talked about a late person, and I remember the best man at my wedding, Richard Smith, late Chairman Smith. Premium taxes used to, that stuck in his craw every time we had a conversation about the premium taxes going back to local governments and the opportunities they had to lower some of the costs to the consumers. And that was a pulpit he stood behind and preached many, many times. So I appreciate y'all addressing some of that. But
I miss him too. I
yeah.
miss him too.
A man of unquestionable ethics and character, unquestionable. Yes, Senator Kirkpatrick.
So we have another LC in our folder, and it's 520191.
No, is that on the flood mitigation?
Yeah.
I think that was something that was brought forth by somebody who's going to testify. That was not originally in our folder.
Okay.
Yes, ma'am.
Thanks.
He wants to speak to some of the mitigation stuff after the testimony on the bill.
Okay.
Yes,
Okay,
ma'am.
thank you.
Any other questions on 1344? Definitely request your approval on that. The other two, Chairman Lumpson has spent more time. I'll cover them, and he can definitely answer any questions on 1262, surprise medical billing, mental health parity, and then general fine authority for repeat offenses and all that. It goes from double to 5 times. And then 1263, that is the premium tax look back that I mentioned, where right now it's arguably unlimited. You and I as a taxpayer, we're going to be held to 3 years, so this puts insurance companies on the same plane as a taxpayer, where if there's an error in your return, you got 3 years to fix it, not forever.
And a quick question I have is, in this building, we're all about the math. When somebody wants to increase a penalty or something, and we throw a number out there, the question is always, how do we get to that number? So how did we go from double to 5? And I appreciate Chairman Lumpson discussing the how long it had been. 30 years and 15 years, I think, were the two examples. Did we use any economic identifier there to get us to 5 times?
As Chairman Lumpson mentioned, that the length of time by which it has not been updated, that's one factor. The other factor is, if you look at some of the fines that we increased, we deliberated in the committee and increased those, but surprise medical billing, mental health parity, and then repeat violations, those are the ones that folks are not getting the message on, and we need to send the strongest message. So instead of doubling, going 5 times.
And I appreciate that. Yes, sir.
I would just add that because the fines have not been revisited in those periods of time, many of the companies that are bad actors that are doing this continue to do it because they'll just absorb those lower costs into their business model.
Yes, sir.
So it has little or no effect on them, but by increasing the fines to offset inflation, but also putting a little more bite to it, that makes it more likely that they will comply.
So inflationary measures, and we need to send a strong message.
That's right.
Especially those whose profits could easily absorb some of these fines as they are today. And we just saw it, I think, in mental health parity, right?
That's right.
Where we worked really hard on a bill to offer those with mental health issues an opportunity, and then we had some that were obligated under the law that we passed in this building who ignored that legislation. Chairman Kirkpatrick.
Yeah.
Chairwoman Kirkpatrick.
Thank you. What this makes me think about is that we pass a lot of laws in this building, but really it all comes down to compliance.
That's right.
And enforcement. And the insurance commissioner is asking for more authority, and I agree with that.
Thank you. I appreciate that.
And I would say it's those 18 House members and the citizens of Georgia. We heard from a lot of folks on these things, but the fine, for instance, $25 million, that'd be $125 million. So nobody can call that a cost of doing business. That's a real hammer to change behavior.
Yeah, Chairman Steele.
Just processing the math on this, when was the last time that the rates were set on this?
The unintentional was about 15 years ago. The intentionals have been revisited for 30 years.
Increasing fines by 5x, on average, I guess that's where we're doing is a 5x multiple on all of these. Is that going to stop bad actors, or is this just creating? It feels to me kind of like a bill that floated around last year about debanking and creating private right of action and complaints, and just does increasing fines prevent bad actors, or is this just an undue?
I don't know that it
punishment?
will prevent them. I think it probably will be a deterrent, but preventing it, if their model, if they absorb it, but I think having the ability to do that is something that we need to be able to do.
Chairman, would you agree that it exposes them?
Absolutely.
And that to the consumer, they see that and maybe let that weigh into some of their decisions? Possibly,
Absolutely.
yeah.
Absolutely.
Sorry, Chairman Steele.
Thank you, Chairman. I'm just trying to understand. Anytime we talk about penalties, I always ask the question, is it rampant enough that we're needing to assess penalties so that we're going to stop it, or is this a solution in search of a problem?
Chairman, if I could respond, the 3 fines that went to 5-fold, those are ones with a lot of repeat problems, and it's a maximum fine also. So if the circumstances don't dictate a 5 times fine, it could be lesser than that. But these are ones, you had some great legislation on the ambulance surprise medical billing. There are repeat examples of surprise medical billing. We've come back every year for about the last 5 or 10 years to try to attack this, and this sends a clear message: don't do it to Georgians. Let's treat customers, insurance customers fairly, patients fairly on surprise medical billing. Mental health, that's a workforce and a child care issue. People can't care for their kids, can't go to work if they or one of their kids is having mental health issues. So making sure that mental health is complying with the law is important. And then the general fine authority, these are for repeat, flagrant, stubborn examples of somebody being a repeat offender. And so 1344, these have more modest increases in the fines based on neighboring states, but these are 3 problem areas in 1262 that justify having a maximum of 5-fold.
And that maximum, like you said, is not the fine they could get hit with every time. It would be based on the preponderance of the evidence as to what they've done, their habits of being bad actors. And again, I think the exposure says a lot when whatever newspaper's still alive puts out the information that the company ABC has been fined a substantial amount, and this is the same type of insurance we all carry to some degree, health care or auto insurance and home insurance, so it sends us a strong message.
And speaking of exposure, I'd
Yes,
like to give some positive exposure, if I could, on the companies who have done
Absolutely.
good. American Integrity Insurance entered the Georgia market. Donegal Insurance re-entered the Georgia market. Other states are losing companies. We've got companies coming here. The 10 companies who have cut rates in the last year are State Farm, multiple Liberty Mutual entities, Safeco, Southern General, Progressive, Hanover, Go Auto, Allstate, and Country Mutual. And I believe there are 2 who are in the final stages of completing their rate reduction. So we got 10.
We might have to steal that testimony out of your Dropbox and use it this coming November, right?
Absolutely.
Yeah.
It's
That's
something.
correct.
It's something that benefits 9.1 million Georgians.
Yeah. And again, that benefit is from a piece of legislation we passed last year.
That's right.
And your contention is if we pass this legislation, we'll have similar responses based on this moving forward,
We'll
right?
keep that good momentum up. And also, if you look around the country, this does more for insurance customers and the Georgia insurance market being healthy than anywhere else in the country.
Yeah, and I don't want to bypass on the abuse that the insurance industry has also taken since tort reform, because a lot of things got put out, and I think one of those resulted in the death of an innocent man in New York City because the insurance companies had been painted as just these evil things, but they are coming along and doing exactly what's right. So they want to be part of the solution too, it sounds like.
That's right. And State Farm, in addition to cutting their rates, they did a rebate. They did a refund nationally.
Well, I won't tell you who covers all my stuff, but I got a check, and I greatly appreciate that too. Anything further you'd like to talk about the legislation you or Chairman Lunsford?
we appreciate your hearing of this and respectfully request approval of it. If you want to put them all in 1344, as Senator Steele asked, that's the easiest way we know how to move this forward.
Yes, I appreciate that. We've got a few people signed up that want to talk. We'll let them talk. I've got to have this guy, he's got another appointment at 8 o'clock, and we have a full day, but we're going to get some of these other folks up here.
And change the title of 1344 to affordability. That was the one amendment there.
That's an important word. Todd, you want to come up? Good morning.
Good morning, Mr. Chairman, members of the committee. I'm Todd Edwards with the Association of County Commissioners. I, unlike the previous speakers, am not an insurance expert. However, ACCG is in the insurance business. I looked it up real quick. We cover at least 99% of the counties in the areas of workers' compensation, property and liability, group health, inmate medical. These are fine bills. I come up to speak to you on one limited specific provision, which may have been in the substitute, but it was in the original House Bill 1344 as passed by House. This was the LC 521035. And I would have you focus, and you may have the language in front of you. It was in that bill. It was section 5 lines 231 through 232. Thank you very much. And it dealt specifically, so it's 5.1 section in subsection F, on what counties were required to demonstrate in a report on how they use those funds. I understand that's be corrected. They're showing. If you'd like for me to speak on our original concerns, I'll be happy to.
If you speak on you talking about the, how related to the bill that Chairman just spoke to?
Yeah, and they are showing me now that the language
The
that we have
premium
asked
tax?
for, had been corrected. I can
Have
go
been
on or cut it
corrected or
short.
made more, take more,
They've cut bureaucratic red tape, make more sense with what we're already required to spend it on and our current reporting requirements as counties.
right. I
under
think you and I
state
had a
law.
conversation about this the other day. Would that be correct?
Yes.
Yeah, okay.
Yes, we
You want to
did.
touch on that change real quick?
Yeah, so in that section, it wanted a report it said each year on passenger, how we use these funds, insurance premium taxes for passenger automobile premium decreases, fire safety initiatives, property damage prevention. It had a list of various things. Well, under current law, Georgia counties are limited in what we can insure or use our insurance premium tax revenues for. And that's in this code section 33-8-8.3. And we're limited to using it on fire, police, solid waste collection, streets and sidewalks, flood reduction, and other services in the unincorporated area, or property tax relief. So there is some conflict there. And I will also note that in current state law, Georgia counties are required to report how we've used these premium taxes for these purposes. So our concern was that the language in the original 1344 conflicted with what we're currently, A, required to spend them for, and B, was another report when in fact we're already doing one.
How do you currently report it?
In the budget each year.
Right,
Counties,
so-
annual budgets, how they are spending their IPT on the above authorized services. I believe in the committee earlier, I showed you an example from Troup County.
Right,
How
and so basically, if a citizen needed to know how y'all were currently spending this premium tax rebate, they would get a copy of the county budget?
Yes, that is true.
So it's not a separate report submitted to the insurance commissioner or anything like that, correct?
It says in here, and this is 33.8 or dash 8.3, specify in such budget the amount of such funds expended by authorized by this paragraph. So yes, it's in their county budget.
Right, it's in the county budget, the minutes and discussions of the budget. So it's not a separate report that is sent out to the insurance commissioner or anyone else in state government, correct?
That is correct.
Okay.
They may receive it somehow, but it is listed in our budget.
If there's any questions, somebody could always get a copy of the budget and review how these how these monies were spent.
As far as counties are concerned. and
Correct.
that's
Counties,
who
I want to
represent.
be
Yes, sir.
clear, counties are held to a different standard as of right now than municipalities.
That is correct on both what we are spending these taxes on and what we are required to report.
Right, and your change would bring a little more parity, which is the word we like.
I believe it would, yes. Well, it would line these two things up for counties. I can't speak for municipalities in this regard.
Right, yeah, let's don't speak for them.
No, sir.
Chairman Steele.
Chairman, just point of clarification, did I hear Todd Edwards from ACCG on record say that it requires even a blue ribbon House committee, it requires a Senate subcommittee to perfect legislation?
I think that's his official testimony.
I think it was. Thank
It
you.
is, and it's codified in history now. He may try to backtrack on the next bill, but we've got him right now.
Well, I have to be fair and honest. These the changes that
And I
we
just
have
heard him say he has to be fair and honest.
incorporated were, I think it was Thursday or Friday of last week, incorporated into two Senate bills that were over on the House. So we're perfecting bills on both sides from respective.
You were
chapters.
doing so well, Todd.
You know,
You
I
were doing
couldn't,
so-
I know who's sitting right
You
behind
know
me.
who's sitting behind you, didn't you?
Yes, sir.
He was taking notes, I want to point out, yeah. No, listen, I appreciate you always being forthright and coming up here and reminding us of the heavy load that ACCG carries in managing the 159 counties. Y'all do an outstanding job, and I promise you, we do not like to be involved in local issues as much as y'all think we like to. But I think without your association doing your job, we would be much, much more involved than we are today. And so I do appreciate the way y'all do your work.
It's my pleasure. Thank you, Mr.
Yes,
Chairman.
thank you. Neil, you want to come up and speak to, and be grilled by Senator Kirkpatrick since you gave her something?
Thank you, Mr.
And
Chairman.
my first question is going to be, have you spoken to the author of the bill about?
No, I have not spoken to the
Okay.
author of the bill. I regret that. I didn't go to the study committee either.
Yes, sir.
I've been as negligent as I could be on this matter, but
Okay.
that's pretty typical for
Inter-
people in my line of work.
Introduce yourself, please.
My name is Neil Herring. I'm a contract lobbyist. I'm here on behalf of the Georgia chapter of the Sierra Club, and I want to respond to the chairman's initial remark that this committee is to vet issues. I have an issue that I want vetted, that I've wanted vetted for some time, that's never been vetted, and I'm glad to be here. Thank you very much.
We're here to vet.
I know it. You're doing a great job.
Thank you.
This is not a place where I feel welcome. Based on what I've listened to, these people know an awful lot about their subject matter. I'm not so blessed. But speaking of blessings, I've always heard that Charleston, South Carolina has more history than they can use locally. And I've always thought about that as probably a useful analogy. Glenn County, Georgia has more environment than they can use locally. And my work at the legislature over a long time has really depended on Glenn County and its representatives to bring forth issues and solutions and whatever a lot. And this subject matter that I'm here about, which is floods, is a Glenn County specialty, as others. On the matter of local insurance premium tax funds, Representative Hogan and I, a couple, 3 years ago, I don't know, some time ago, were able to get flood risk reduction expenses covered by the county for the unincorporated areas. As y'all know, the cities can spend the money on anything. The counties have a list. And we got flood risk reduction added to the county's duties, and we've got a definition of it that's a pretty good definition. And I want to say that the Office of Legislative Counsel has been really a great group to work with on this whole matter. They'll get it in their teeth and do it. And the language that you refer to was what has evolved over literally years of torturing ourselves over this subject matter. if you want to accomplish something in Georgia, you got to have an income stream first. Then worry about what you're going to spend it on. And so I've spent a lot of time looking at income streams, and I discovered that the school voucher people, or scholarship funds, whatever they call themselves, have been going into the insurance premium taxes. And I thought, well, there's an odd source of money, and it's somewhere $500 million a year, something like that. And I thought that, the subject matter I'm interested in is more insurance related than education. So insurance premium taxes may be a good place to go. And so that's where we've been. And flooding is a growing problem for the world, for our state. We're a wet state. We may be the wettest place in the United States. I'm not sure, but I think there's an argument to be made there. Climate may or may not be changing for various reasons, but the changes that we're seeing are almost all expressed through the medium of water. Water is nature's main tool for changing things around, temperature, energy, all that. And flooding in Georgia has gotten to be a disaster. Last year in September, I believe, there was what they call a microburst in Atlanta on Marietta Street, which is on a ridge, where an automobile was actually submerged in rainwater in the space of a few minutes. And we all remember the story of the coffins washing up out of the ground in Albany during that hurricane flood. I mean, there's just the flood stories. This session is the first session I can remember in a decade when there hadn't been a flood story where some legislator told me it flooded in places where it never flooded before. And we've all heard that line because it's true. Cobb County, which is a relatively high elevation area, has got horrible flooding problems. The coast has a flood every month on the King Tide. I mean, so this issue needs to be addressed, and my thought was, well, go to the insurance premium tax and give the localities that want to address the problem, not any locality, but if they want to address it and have a plan, go get some money from the insurance premium receipts.
Hey, Neil, I'm the air traffic controller, and you're the pilot, and I'm just trying to help you land this plane.
Thank you, sir.
So if we could get to what you want to do, because
what I would like to do is for y'all to think about allowing the carriers to take insurance premium credits and give it to counties with certified flood funds to use for things like matching funds. We've had floods in Georgia where there was no matching funds. You couldn't get the federal money because you didn't have a match. Stuff like that. And also to deal with infrastructure issues that are not on private property. Streets are the main conveyance of flood water.
And you're talking about infrastructure in general, or you're talking
Yes,
about
sir.
infrastructure related to flood control?
It would be in flood risk reduction.
Flood risk reduction.
Right. Okay. And one thing that has not been really emphasized enough in my mind is there are places that are plainly flood targets where insurance, the law we've got allows people to rebuild stuff that they shouldn't be rebuilding because it's going to get washed away again. And so buying those properties is the easiest way to avoid that cost in the future. So that would be an example of the use of a flood fund. Okay. So I don't expect y'all to do this. I just, the idea of giving the carriers the opportunity to to fund interested localities seems like a good approach to this problem. It's a local problem with a local solution.
Neil, I really appreciate you. I appreciate all the work you do on the environment. I respect the organization that you're representing here today. I was invited to speak at one of y'all's programs in Troup County. When I finished, I had people come up to me shocked that I was a Republican, and I really do appreciate that.
The environment is a Republican issue, sir.
No,
Theodore Roosevelt invented it.
Neil, his portrait hangs in my office.
You know what he called the avian creatures? Citizen bird.
Well, what I want to recommend is I'm going to recommend that you meet with a creature. He's a good creature. He's a friend of mine, Todd Edwards, with ACCG. Have a conversation with him because you probably, I'm guessing y'all haven't spoken yet.
Oh, no. Todd and I have talked about this for years.
Okay. Get with Todd, and if I'm happy to look at this and talk to the full committee about this. I've
talked to the chairman, and I've talked to Senator Hodges,
Neil,
who's from Glenn County.
Neil,
It's Glenn County is where you go.
When the pilot talks too much, the plane crashes.
Thanks, sir.
Okay? Thank you.
Appreciate it.
All right.
Thank you for your time, your effort.
Neil, I appreciate you as always. Thank you. Mr. Chairman, you want to come back up and close this thing?
In conclusion, that was a good example. There were a lot of good ideas out there that it was uncertain whether it would increase premiums. These four bills that we've got These will make insurance more affordable. They will also improve claims processing and mitigate claims in a way that won't increase premiums. So there are a lot of good ideas that can have further discussion, but we will guarantee these 4 bills will keep the momentum going of decreasing premiums.
Well, doing my homework this weekend, I took the legislation home with me and read through the LCs that we heard from today and a couple of them that we didn't. And one thing I saw is that we're closing the loop on a promise we made last year when we talked about tort reform. And there was one segment of society that thought we were just targeting them because we hated them and just they were mean because they were interrupting us with commercials every 15 minutes. But we made a commitment that we were going to look at all aspects of this problem. And I believe that the legislation I read this weekend is a gallant and hard effort in doing that. And so I do appreciate that. Now, I would be remiss if I didn't ask, is there anyone else here? I'm not seeing anyone signed up unless somebody double signed that wants to speak in favor or opposition of any of this legislation that you've heard from.
Robertson,
Yes, ma'am.
I could be on the list, but I don't want to hold up.
Okay. Kim Jones, if you'll step up, Ms. Jones, if you'll sit next to her at mic 3, I'm not going to ask the chairman to get back up.
And there was one more typo I found. Line 240 on 1344 required, just correcting the spelling on that. So affordability and required, and we're good on 1344.
Okay, so what was the word?
Required on line 240, just a misspelling of required.
Okay, so the House did not misspell affordability.
I think so either the House or ACCG misspelled required.
ACCG did not misspell affordability. They may have misspelled
It was their
required.
amendment.
Yeah,
So,
it was their
all right.
All right,
Thank you.
thank you.
Very quickly.
And I want to say real quick, Kim Jones, if you'll introduce yourself, Kim.
Sure, Kim Jones, Executive Director of NAMI Georgia, and co-founder of the Georgia Mental Health Policy Partnership. And I want to thank Chairman and Representative Reeves and Lumpson for your hard work on this bill. We do support how. I'm speaking to House Bill 1262.
Yes, ma'am.
Increasing the parity fines. I also want to thank the whole General Assembly because you guys have done an awesome job with mental health. In 2022, we were 51st in the nation in access to care. We are now 46th. We've moved up the chain 5 times, while other states are working twice as or as hard as we are for mental health. So I think that speaks volumes to the work that you guys have done as a General Assembly. I also want to point out that parity is the foundation of fixing mental health access to care. That is why we started there. You have to have people who pay. And I just wanted to speak to making sure that we all understand, especially many of you will be leaders next year, that this parity and having insurance cover the people who are affected by mental illness keeps them from going into the Georgia safety net and keeps from the state paying for these people who are impacted by mental health. As far as the going up 5 times, I want to remind everybody that federal parity was federal law for close to 15 years. And as one of you mentioned, having to enforce a law that's already there, that is what Georgia did in House Bill 1013. And I just also wanted to speak to that workforce is a supply and a demand issue. Unfortunately, many of us who can afford to pay cash out of pocket don't have a problem finding healthcare workers in mental health. Insurance companies could pay more to make sure that we have the access to workforce that we need. So I feel like these fines are 5 times is almost not enough, quite frankly. But as an advocate, of course, we feel that way. Finally, next year, we hope to ask this gracious body to also ask for those fines to go to a behavioral health fund so they can go back to the people who didn't receive the care that they can. So in essence, we support House Bill 1262 and all the hard work that everybody here is doing to make those parity fines happen.
Thank you. I appreciate that. And I hope you don't forget that the House and the Senate passed an amended budget budget that included over $400 million for the first mental health facility in Georgia since the
Absolutely.
1960s.
Absolutely.
So we do take it serious on both sides.
Absolutely.
And we appreciate NAMI's involvement. I've been involved with NAMI for over 20 years, and I think y'all do incredible work.
Thank you.
In our communities, and thank you, and we appreciate you here today.
Appreciate it too. Thank you, sir.
Chairman, I appreciate everything. Any other questions from the committee members? As you heard me say it before, I've read through these things. I think y'all did a stellar job doing the work. I'm going to reach out to the chairman of the committee. I'm going to recommend a full hearing, and I'm going to support what y'all are doing and push that we get this legislation perfected, well-crafted, and get it passed.
Thanks a lot.
Is my hope. I appreciate you, my friend.
Appreciate you all.
Thank you, Chairman, and thank you, Chairman Lunsford. This meeting is adjourned.